Excellencies, Ambassadors Francois Alabrun need to make cooperation a permanent point on the agenda of future sessions. Through this plenary, the Assembly continues to stress each year the crucial importance that there is of having increased cooperation between states to support the Court in an effective way in the fulfillment of its mandate. And I wish you all a constructive and enriching discussion. And I am honoured to participate in this first segment alongside my esteemed colleagues from the Court. I now give the floor over to the co-facilitators for cooperation, Ambassador Alabrun from France and Ambassador Buffet from Senegal, who have the honour of making a few short introductory remarks on this subject of great importance for the success of the work of the Court. Thank you, Madam President, for having opened this session. Ladies and gentlemen, President of the Assembly, President, Deputy Prosecutor, Registrar, ladies and gentlemen, ambassadors, ladies and gentlemen, I would like, in my behalf and on behalf of the French Ambassador Francois Alabrun, welcome you to this plenary on cooperation under the Rome Statute. It is with great pleasure that I join you today for my first participation in the Assembly of States Parties under the Rome Statute and in my first plenary session on cooperation as co-facilitator. This occasion gives me the opportunity to reaffirm here the commitment of Senegal to work together with France to ensure the facilitation of cooperation through a dynamic framework which is constructive with states parties, the Court, the other observing states and the international organizations and civil society, with a view to helping to ensure that we can meet the commitments by ratifying the Rome Statute in cooperation with the Court. Ladies and gentlemen, I would like to recall the essential nature of cooperation with complementarity. That is the two pillars which underpin the system. The efficiency of the International Criminal Court largely depends on the good quality of cooperation that it has with member states and even non-member states, as well as with international organizations at universal, regional and sub-regional level. It should also be stressed that there is no international criminal justice without true cooperation between states. There is also no effective fight against impunity without the sharing of responsibilities between the Court and the competent states. This year, once again, the Ambassador of France and myself have mobilized ourselves to conduct the mission entrusted to us by the Assembly of States Parties and the Bureau. In accordance with the recommendations on cooperation, France and Senegal, in their capacity as facilitators, have held a series of meetings throughout 2024, in particular on arrests, which is fundamental for the functioning of the Court, on the security of the Court staff and the freezing of assets, together with the facilitation on legal aid. The recommendations of the independent experts report concerning cooperation, the secure platform on cooperation and the voluntary cooperation agreements have crucial importance for the Court. The report of the Bureau on Cooperation goes into detail on the meetings and the actions carried out. We shall start with our plenary today by giving the floor to the head of the organ of the Court, who will remind us of the essential aspect of cooperation with the Court before continuing with an expert panel, which will discuss the different ways in which states parties can increase their cooperation with the court using existing tools. I would now like to give the floor to my colleague, my very dear friend, François, who will present our first segment.
Merci beaucoup, cher.
Thank you very much, Matulay. President of the Assembly, President, Deputy Prosecutor, Registrar, ladies and gentlemen, ambassadors. The first segment of this plenary session is given over to high interventions from high representatives of the court, which I very much welcome, and I thank them for their presence here as well. Madam President of the Assembly, Päivi Kokorento, the President of the Court, the Deputy Prosecutor, Manday Nyong, and the Osvaldo Zavala-Gile, the Registrar, who will show the importance of cooperation with the Court. And of course, I will give the floor straight away to the President of the Assembly of States Parties. You have the floor. Excellencies, distinguished participants, it's a great honor for me to be able to address you today on the crucial issue of cooperation and the essential role that states parties can play to support the International Criminal Court. The success of the independence of the court is based on cooperation and collaboration and the commitment of states parties. The court cannot fulfill its mandate without this cooperation, which must be effective in different key areas. Today, I would like to highlight some of these fields, and in particular, judicial cooperation, voluntary agreements, and political support.
The court's ability to investigate and prosecute depends on timely and effective cooperation from states parties. Judicial cooperation is key for numerous and critical aspects of the court's work, including collection of evidence and case building, facilitating access to national legal frameworks and ensuring that national systems can comply with ICC requests is crucial to this end. Despite encountering difficulties, the court has made progress in tracking and freezing assets, but states parties must step up with decisive action to fully support the court in executing its mandate, continuing to strengthen national legal frameworks, responding swiftly to requests for assistance, and designating national focal points will greatly further enhance the court's efforts to recover assets, resulting in more effective proceedings and an increased capacity to hold perpetrators to account. In this context, an important achievement of the cooperation facilitation is the cooperation platform developed together with the court and the ASP Secretariat. States parties are encountered to actively engage with this secured interactive tool designed to share national procedures and best practices in asset identification, freezing, and seizure. Additionally, witness relocation, interim and final release, as well as enforcement of sentences agreements are crucial. I commend Poland for signing an agreement on enforcement with the court on Tuesday. By signing the agreement, Poland has demonstrated a concrete commitment to the court and its mandate, encouraging other states parties to follow its steps in the near future. While significant achievements have been made, the ICC is increasingly confronted with challenges it was neither designed nor prepared to address, ranging from sanctions and other coercive measures to cyber attacks, all of which not only jeopardize the safety of the court's personnel, elected officials, but also the security of witnesses and victims. Additionally, protecting outgoing officials and their families from potential threats after their departure from the court is critical. In this context, the legal framework provided by the Agreement on Privileges and Immunities of the ICC is fundamental. By ratifying this agreement, states parties provide the court with a strong legal foundation and necessary protection. I urge all states parties that have not yet ratified the agreement to do so. On the final but very important note, today 30 public arrest warrants issued by the court remain outstanding. Prioritizing these warrants and improving coordination between states and the court is essential. States parties must address barriers that hinder arrest operations. States parties must also provide the political and the operational support necessary to overcome challenges. Fostering cooperation through diplomatic and political efforts is key to ensuring the execution of the outstanding arrest warrants, and with them the continued success, sustainability and credibility of the ICC. In a fragmented world with challenging and evolving geopolitical dynamics, the court has remained steadfast in its mission. However, continued political support and tangible cooperation from states parties are crucial to enabling the court to address its vulnerabilities and to prevent its operations from being compromised. The integrity and security of the court depend on safeguarding its infrastructure, personnel, and independence. Mesdames et Messieurs,
ladies and gentlemen, by way of conclusion, with regards to the challenges that the ICC is dealing with, they are not insurmountable. Their success depends directly on the active commitment of the states parties. It is not only about fulfilling obligations, but also to guarantee the future of international justice. We have to strengthen our cooperation with the court and put in place solid mechanisms to overcome these challenges. The ICC, our ICC, is the embodiment of our common commitment for justice and our responsibility. Together, we can help it to fulfill its mandate. Thank you very much for your attention.
Merci, Madame.
Thank you, Madam President. I would now like to give the floor over to the President of the Court. You have the floor.
Madam President of the ASP, Excellencies, ladies and gentlemen. It is a great pleasure to address this plenary meeting on cooperation. I thank the co-chairs for inviting me to speak and for their excellent work as co-facilitators on cooperation. This is a crucial topic. Without cooperation, the court would not be able to perform its mandate. I will first address the topic of arrests. It goes without saying that arrests are necessary for the functioning of the court. There are currently 30 pending arrest warrants that are public, and the court relies on states to enforce them and transfer the fugitive to the court. This is not only a legal obligation of states to the court under their own statute, but it is also a responsibility towards other states parties who took the commitment to arrest fugitives, and a responsibility towards victims who await justice. When states have concerns in cooperating with the court, they may consult the court, provided that they are genuine and meaningful and act in a timely and efficient manner. However, it is not for states to unilaterally determine the soundness of legal reasoning and use that as an excuse to not abide by judicial decisions. This issue is also closely linked to the question of non-cooperation. Let me underline that when a chamber finds that there is non-cooperation, it is a legal finding by the court based on the statute. The political considerations are left to the Assembly or the United Nations Security Council once the legal finding is made and after there is a referral. I would also like to underline the importance of the agreement of Privileges and Immunities of the Court, the APEC. I call on all states to ratify and implement it. It is crucial for the ability of the courts to perform its mandate. In a time of threats of sanctions and attacks against the court, the APEC complements Article 48 of the statute and guarantees the independence of the court as it defines it in greater detail the necessary privileges and immunities of the court and its personnel. This is crucial for the ability of the court's personnel, including counsel, to conduct official missions in a safe manner and without fear of interference with their independent functions. The APEC also includes the protection of the court's funds, property, and assets from interference, search and seizure, as well as inviolability of the court's documents and communications. These are not matters of convenience. Rather, they are essential guarantees for the court's independence and the integrity of its investigations and proceedings. Accordingly, I urge renewed attention on these important issues, which have a real impact on the court's operational efficiency in a time of political pressure against the court. I must therefore express my concern about the fact that 46 states parties are yet to join the APEC, and I urge them to do so without delay. Excellencies, ladies and gentlemen, I'd like to finish my remarks with an expression of gratitude to France and Senegal for all their efforts as co-focal points on cooperation. I also reiterate the Court's gratitude to all states and organizations that extend their cooperation as well as crucial political support to the ICC. Thank you very much for your attention. Thank you.
Merci, Madame.
Thank you very much, Madam President. I now give the floor to the Deputy Prosecutor of the Court. You have the floor. Thank you. Madam President of the Assembly of States Parties, Madam President of the Court, Excellencies, Registrar, ladies and gentlemen, I would like first of all to express, on behalf of the prosecutor and on our entire office, our gratitude for the support and the cooperation that states have continually showed to us and also our partners. This cooperation is fundamental for the success of our operations. It's crucial in order to increase the impact of our collective actions in the fight against impunity. You will have heard a lot over the last few days about the fact that the Court is now dealing with unprecedented challenges, issues which put to the test our resilience and our capacity to respond to them. During the different sessions of this Assembly, the speakers have reminded us of this hard reality with which we are confronted. And I should also add here that it was reassuring to hear the delegates of states reaffirm from this hall their support for us in this extremely difficult time that we are going through. Cooperation and solidarity at international level are necessary vehicles in order to realize the ideas proclaimed in the Rome Statute, these ideals which are the basis of our civilization. They are at the same time crucial instruments to render effective justice to victims of atrocious crimes, and victims who, unfortunately, are in all parts of the world. I would particularly like to thank the co-facilitators, France and Senegal, for their leadership, which they have demonstrated. Excellencies, Mr. Alabrun and Madame Tlulay, you have our profound gratitude for your excellent initiatives, as well as for your constant efforts for mobilization to advance cooperation. I would also like to express my gratitude for having associated our office with your work. This collaboration has been necessary to make people understand our challenges and also to have exchanges with privileged partners in a constructive way on major subjects. The exchanges that we have had recently at the residency of the Ambassador of France on arrests have once again been an excellent occasion to reaffirm the enormous importance that we give to this question, including the issues of arrests, which the President has just spoken about, and which today there are a significant amount of arrest warrants which have been issued which have not been carried out. And I would like to thank the Registrar and the Registrar's teams who continue to strengthen our capacity to localize suspects. And this is all the more the case. So this has been this barrier. It must not prevent us from doing our work. And we wish to eliminate these barriers. And I would like to thank the Registrar and his team once again for that. It's also necessary to go even further on other aspects of cooperation with states, with a view to accelerating our investigations with all necessary rigor, wherever the office is called to intervene. The vision of concentrating the energy and competences of our office to ensure the greatest impact in the prevention and repression of atrocious crimes is based for us on a fundamental determining factor guaranteeing effectiveness. The office has the essential cooperation of states, technical partners, and civil society organizations. The dynamism of deepening cooperation in all forms is based on our mandate, and it is crucial given the multiple challenges that we face. Excellencies, ladies and gentlemen, I would like to reiterate our gratitude to all states, to civil society organizations for the excellent contributions and consultations on our general documents and on cooperation and complementarity in partnership with all the actors involved. Reinforcement or capacity building efforts will continue to optimize our technological teams, and this will facilitate more efficient and expeditious treatment of requests for cooperation increasingly received by states and to meet our cooperation needs. Often what we see is that this is an aspect which is less known, but just as much that we ask for cooperation, we are also people who are able to provide cooperation. And I think that today this is something that we've managed to do to the satisfaction of many entities. And the ambition that we have to intensify our support for national procedures by sharing necessary information and reinforcing resources is something we very much value. Furthermore, we want to ensure that we can have necessary synergies in order to reduce the impunity gap for international crimes and to render justice to the communities who are the most affected. Thank you for your attention. Thank you, Deputy Prosecutor. I now give the floor over to the Registrar.
Madame la Présidente.
Dear Madam President of the ASP, Your Excellence, Madame Baffet, Ambassador of Senegal, Your Excellency, Mr. Alabrun, Ambassador of France, President of the ICC, Prosecutor of the ICC, Excellencies, ladies and gentlemen. It's both an honor and a privilege to address you today here at the plenary session on cooperation of this 23rd session of the Assembly of States Parties. Allow me to express my most sincere gratitude to the Presidency of the Assembly, as well as to the cooperation co-facilitators, Ambassador Buffet and Ambassador Alabrune, for their vital support for this most important discussion. This is a key issue for the session, and it couldn't come at a better time. And the question we're all asking ourselves is, how can we reinforce support for the court? And we're meeting here in this august assembly, and every single one of us knows that we're at a critical turning point in the history of the court. At a time when the court's work is drawing growing attention from outside and is confronting new challenges, we are all very aware of the commitment that we undertook as states parties to the ICC in the preamble of the Rome Statute, affirming that the most serious crimes affecting the international community as a whole must not remain unpunished. We also recall the crucial importance of cooperation when it comes to enabling the court to fulfill its mandate, that is, to fight against impunity for the most serious crimes ever witnessed by humanity. Allow me to now continue in English.
Cooperation is the bedrock of a successful model of international criminal justice, as envisioned by the Rome Statute. Without effective cooperation, the court cannot fully realize its mission to deliver justice for victims and hold perpetrators accountable. Judicial cooperation in this context can take several forms: support to the judicial proceedings, cooperation with defense teams, identification, as well as freezing and recovery of assets for the purpose of legal aid, and potential forfeiture for future payments of fines and reparations to victims. It can also be what we refer to as voluntary cooperation, such as asking states to accept on their territory witnesses for protection purposes or defendants on interim release. It can be related to arrest and surrender of suspects at large, which remains a crucial endeavor for the court and an absolutely critical, if somewhat formidable, responsibility of our states parties to cooperate in this context. Let me take a moment to touch on the political challenges in this regard. We are fortunate to rely on a solid legal framework provided by the Rome Statute, which governs this vital area. The number of suspects at large has grown significantly over the past few years. To date, there are 30 suspects at large for whom the court has issued public arrest warrants. It is a troubling reality that some of these arrest warrants date back from over 20 years ago. In 2024, the registry, in close coordination with the Office of the Prosecutor, enabled some states to launch arrest operations, one of which concerned one of the old arrest warrants, and it required the buy-in and support from 4 different states. While states bear the primary responsibility for executing arrests, the registry of the court, in consultation with the Office of the Prosecutor, must continue to play a pivotal role in coordinating these efforts, providing information, and engaging consistently with states to secure tangible results. The establishment of the Judicial Cooperation Support Section and the creation of the Suspects at Large unit within the registry at the beginning of this year reflects our commitment to enhancing coordination and prioritizing arrest operations. The court is also working closely together through the revitalization of the Registry and OTP Suspects at Large Working Group in order to adopt more effective strategies and provide the maximum amount of information to states to facilitate prospective arrest, and are working behind the scenes to capitalize on opportunities. Additionally, the recommendation for increased engagement with states parties on outstanding arrest warrants, championed by France and Senegal, offer a vital roadmap for future concerted action between the Court and ICC states parties. While there remain obstacles ranging from operational, legal, political challenges that hinder cooperation, there are important successes to highlight. The simultaneous arrest of 4 suspects in the Bemba et al. Case across 3 jurisdictions and 2 continents, and the surrender of Dominic Onwen and Bosco Ntaganda under complex circumstances demonstrate what is possible when we work together with determination and ingenuity. The cases serve as powerful examples of the progress we can achieve when political will aligns with operational capability. The task ahead requires more than the procedural adjustments. It demands a shared vision and a collective action. And I urge the international community to lend its diplomatic and operational support, ensuring that the ICC has the tools it needs to meet the demands of its mandate. Understanding the political challenges some states face in balancing their legal obligations to the court with geopolitical realities, it is important to emphasize that a coherent and harmonious approach of states parties is vital, with the independence of the judicial process and the rule of law being at the heart of accepting and supporting the court's decisions. At the same time, it is fundamental to highlight that the court is dedicated to maintaining dialogue with our states parties. We also strongly encourage states parties to approach the court proactively in this regard. I would be remiss if I did not mention the impact of threats and coercive measures against the court, its officials, and its staff, which is one of the most pressing external challenges currently. In that context, the ICC is very much linked to the Pact for Future recently negotiated at the UN General Assembly. The pact represents a much welcome renewal of the commitment by states to continue to reinforce and transform global governance and strengthen the multilateral system to tackle the challenges faced in pursuit of a world that is safe, peaceful, just, equal, inclusive, sustainable, and prosperous. A quintessential part of this is the need to reinforce the legitimacy of international criminal justice and the ICC, including as concerns cooperation mandated by the Rome Statute. Justice is not a passive aspiration. It is an active pursuit. Together, through steadfast cooperation and collective resolve, we can turn the ideals of accountability and rule of law into tangible realities. The fight against impunity demands nothing less. I thank you.
Merci beaucoup.
Thank you very much, Registrar. So without any further ado, I should like to open the floor to all of those states who registered to do so. Just because of the time constraints, though, I'm going to ask each delegation to respect a time limit of 2 minutes each. I do hope that all delegations were duly informed of that when they did register to take the floor, and I do apologize in advance if I have to switch off the microphone of any speakers who do exceed that 2-minute limit. So I'm going to beg your indulgence and ask you to kindly respect that. And so without any further ado, I'd like to hand over to Sierra Leone, who's requested the floor.
Madam President, co-facilitators, excellencies, distinguished delegates, Sierra Leone attaches great importance to the obligation to cooperate with the International Criminal Court by state parties to the Rome Statute. We are convinced that cooperation is the cornerstone of the court's effectiveness and outreach. Without the full and unreserved cooperation and support of state parties, the court cannot fulfill its mandate to ensure justice for victims and end impunity. In this regard, my delegation commends the Bureau's Working Group on Cooperation and welcomes the ongoing efforts, including to address persistent challenges, particularly on non-cooperation. We acknowledge the significant strides made by the court during the reporting period in fostering cooperation through the creation of the Judicial Cooperation Support Section and the development of innovative strategies by the Office of the Prosecutor. These efforts, including the new policy on complementarity and cooperation and the establishment of the tracking and information fusion selection, reflect the court's commitment to addressing operational challenges and strengthening the Rome Statute. We commend these proactive steps as they enhance the court's ability to execute arrest warrants, recover assets, and relocate witnesses. Cooperation must be practical and consistent, including executing arrest warrants, protecting the court's personnel, and safeguarding its operations. However, as highlighted in the Assembly's report, non-cooperation remains a significant obstacle, seen in the failure to execute arrest warrants, delay in sharing information, and gaps in the assistance needed for investigation and prosecution. These issues undermined the Rome Statute and the credibility of the international justice. Sierra Leone, as one of the focal points on non-cooperation, alongside Mexico, Poland, and Vanuatu, takes this opportunity to urge all state parties to fulfill their obligations under the Rome Statute and engage constructively to address issues of non-cooperation.
I'm going to ask you to wrap up. Thank you.
Merci beaucoup.
Thank you very much. Now I should like to hand over to Mexico, the representative of Mexico. You have the floor. Thank you very much, Facilitator. Ladies and gentlemen, cooperation and assistance between states parties and the international organizations is very, very important if we're going to ensure that that international criminal justice is upheld. Cooperation between the court and states parties and between states parties themselves is vital for the ICC to fulfill its mandate. And particularly Part 9 of the Rome Statute, and more specifically Article 86, is very clear in highlighting that states parties have an obligation to fully cooperate with the court when it comes to investigations and trials of crimes falling under its jurisdiction. And this is translated as cooperation when it comes to financial investigations, freezing and recovering assets, executing warrants for arrest, and among other aspects. And as has already been highlighted by the court through its case law, cooperation needs to be timely, diligent, and make use of all reasonable means available. And Mexico is pleased to reaffirm its position as a key defender of the court's work and the need for the court to be able to complete its work with independence and impartiality. Now, if we're going to achieve that, all states need to cooperate with the prosecutor's office, with the trial chambers, and all the other organs of the court, and Mexico will continue cooperating with the court so that its capacities and necessities are fulfilled. As a focal point for the working group on cooperation, Mexico has been focusing on these kinds of issues and will seek solutions for overcoming the remaining challenges. And the bench says, kindly finish off. Thank you very much, says Mexico.
Merci. Et je donne...
Thank you very much. Now I should like to hand over to the representative of Chile, who has the floor.
Gracias.
Thank you very much, Madam President. actually would like to reiterate its full support and commitment in the long term to the ICC and all of its work in fulfilling the Rome Statute. Ever since it was established 26 years ago, the Court has demonstrated just how vital it is for international justice, and that is why it's currently facing these unacceptable threats, sanctions, cyber attacks, and intimidating initiatives. And these attacks could undermine the administration of justice, but also affect victims and survivors of these heinous crimes. And in this context, we want to reaffirm that international cooperation is vital for the Court, as this cooperation isn't only about sustaining a pillar of multilateral system of justice, it's also a priority for the strategic plans of the Court for the upcoming 2 years. And executing arrest warrants, for example, is vital if we're going to combat impunity and ensure protection of human rights. And that is why currently we are working on a draft law for the cooperation with the ICC. We also want to underscore the importance of the independence and safety of court staff, given these growing threats. And we recognize that these threats actually undermine the integrity of the institution and the very principle of international justice. And in this regard, states parties need to act with firmness, providing diplomatic and public support and strengthening national structures and international structures that facilitate cooperation. And finally, we want to call on all states parties to implement the recommendations from the Court on cooperation. It's not only about arrest warrants, it goes beyond that. But thank you, I've run out of time, so I'm stopping there. Thank you. And thank you, says the chair. And now I should like to hand over to the representative of Armenia. You have the floor.
Thank you, Mr. Chair, and it is an honor to make this statement on behalf of the Republic of Armenia. Of course, the International Criminal Court is the court for the international community as a whole. And the establishment of the court has been quite long, and the effectiveness of the court directly depends on the will of the state parties. So the cooperation by the state parties with the court is crucial and essential element of the court. And we ourselves also have overcome tremendous challenges and sufferings, which led the Armenia's way of ratifying the Rome Statute, and which also underlines the commitment that Armenia has towards the international justice and rule of law. And also it underlines also our trust towards that system, disregarding the threats and also attacks and nihilism that exists today around the globe. We truly believe that the collective cooperation and smooth cooperation with the court as the primary precondition for the success of the court. And thus, Armenia, had the ratification of the Rome Statute and entry into force of the Rome Statute, has very diligently started drafting the implementing legislation for the smooth implementation of the Rome Statute. And we are close to finalizing it. We're hoping to finalize it this year. And of course, that will include a package of legislative amendments. And at the same time, Armenia is also very actively discussing also the possibility of ratifying the agreement on the privileges and immunities of the court, which we understand also another important pillar for ensuring smooth cooperation and efficiency of the court and cooperation with the court system and the justice system as a whole. And of course, we are also considering the ratification of the voluntary agreements for ensuring the enforcement of sentences. That's also another important pillar for state parties to be mindful of.
Je vous remercie.
And yeah.
Thank you very much. I'm going to have to ask you to conclude.
Et merci de votre coopération.
Thank you very much for your cooperation on that. Now I should like to hand over to the representative of Norway.
Madame, vous avez la parole.
Madam, you have the floor.
Norway would like to thank the co-facilitators for their able leadership in the working group on cooperation this year. We would also like to thank the panelists for setting out very clearly the importance of cooperation for their respective organs. This discussion highlights the crucial role both states parties and non-states parties play in supporting the court to fulfill its mandate. The court is totally dependent on complete, effective and timely cooperation from states. It is decisive for its success. Yet it is important to acknowledge that the lack of cooperation from states parties continues to be one of the main challenges of the court. To ensure cooperation is a continuing task. We urge all states to cooperate fully with the court, to allow access, to share evidence, and to execute arrest warrants. Norway is committed to do its part. Norway concluded an agreement on enforcement of sentences with the ICC in 2016. Dominic Ongwen is currently serving his prison sentence in Norway. We congratulate Poland for signing their agreement this week. Norway has also signed the Agreement on Privileges and Immunities and urges remaining states parties to do the same. Cooperation with the court is a legal obligation and must be unaffected by politics. The court is facing challenging times and should, as a bare minimum, be able to rely on the steadfast support of us states parties. We look forward to hearing from the experts during the technical panel and to continue working on improving cooperation together with the court representatives and fellow states parties. I thank you.
Merci beaucoup.
Thank you very much. I should now like to hand over to the representative of Argentina. Mr. Ambassador, you have the floor.
Merci, Monsieur le Co-Facilitateur.
Thank you very much, Mr. Co-Facilitator. Argentina, as one of the originally founding members of Friends of the Court, places great importance on cooperation, which enables states to be better equipped to fulfill their role as part of the court. And in this light, I'd like to underscore the work done by Argentina and the fact that along with 33 other countries, it signed the Hague Convention. And this means that we are better placed to ensure all of the complementarity issues are fully complied with in my country. Under the auspices of the ESG, of the UN, we were able to ensure, we were able to follow his guidelines in ensuring that our legislation also matches the requisite format. We are also committed to ensuring that national international facilitation is ensured by my country. We also wanted to say that all member states, all states parties to the Rome Statute have an obligation to cooperate with the court. Moreover, the Office of the Prosecutor needs to be able to rely on our cooperation and complementarity mechanisms, and this will enable them to maximize the efficacy of their operations when cooperating with national jurisdictions. Thank you very much.
Monsieur l'ambassadeur, je donne maintenant.
Thank you very much. Now I should like to hand over to the representative of Bangladesh.
Thank you, Mr. Chair, for giving me the floor. Madam President, Bangladesh reaffirms its steadfast commitment to the principles and objectives of the Rome Statute and stands firmly in support of the ICC in its pursuit of justice and accountability for the gravest crimes of concerns to the international community. We recognize the significant challenges the court is facing, including issues of non-cooperation and potential sanctions. While Bangladesh respects the sovereignty of all nations, we underscore the importance of dialogue and mutual respect to address any concerns regarding the court's mandate and cooperation. Constructive engagement rather than unilateral punitive measures is essential for strengthening the international rule of law. Madam President, within the 23 years of establishment, ICC has shown progress in issuing arrest warrants for crimes committed against humanity, demonstrating that impunity cannot remain unchallenged. However, the number of fugitives still at large demonstrates the need for stronger international cooperation and enforcement mechanisms. As a state party, Bangladesh encourages all members and stakeholders to support the court in fulfilling its vital mandate. We believe that cooperation and collective resolve are indispensable for ensuring that the ICC remains a credible and effective institution, upholding justice for victims and contributing to global peace and security. Thank you, Madam President.
Je vous remercie et je donne la parole.
Thank you very much. Now, I should like to hand over to the representative of Costa Rica. You have the floor. Excellencies, cooperation is a cornerstone of the court's efficacy, and that is why it's vital if it's going to achieve its aims. Furthermore, the Rome Statute obligates all of us to fully cooperate with investigations and trials, and that's why it's important to translate this into national legislation if we're going to be best placed to fully cooperate. This is important for the vital against impunity. Being accountable for international crimes goes beyond ideology and identity, and we should always bear in mind the well-being of the victims. And that remember that no one is above the law, and if we are going to respect the basic founding principles of the ICC based in the legacy of Nuremberg, then it's important for all states parties to fully cooperate, be it handing in evidence, be it enforcing freezing and recovery of assets, be it through voluntary cooperation. We need to make sure that all of the wherewithal required for the court to fully fulfill its mandate be provided, and that is why we need to make sure that all victims are treated equally, and remember that justice is forged in the fires of equity, and that is why we need to make sure that international justice can be done. Thank you. Thank you. Now I should like to hand over to the representative of the Netherlands. Thank you.
Excellencies, colleagues, without effective and strong cooperation, the court simply cannot operate. With hundreds of witnesses appearing before the court each year, it is vital that there are safe havens available for them. For without this, there simply can be no trials or justice served. Without the key support of states parties in the execution of arrest warrants, the court is unable to fulfill this mandate. For the effective functioning of the court, it is also important that voluntary cooperation agreements, such as release and enforcement of sentences agreements, are signed. With the upcoming conclusion of 2 further trials, we have to come together to support the court and share this burden equally. In this regard, we welcome Poland's signing of an enforcement agreement at this ASP. We as host state stand firmly behind the court and work tirelessly every day to support the operation of the court by, amongst others, facilitating detention, supporting the security of the court's premises, and facilitating the entry of witnesses. To ensure that the court can continue to fulfill this mandate, in this unprecedented climate of external threats, it is essential that states parties strengthen their support for the court. States parties, too, need to be able to cooperate with the court freely without interference from third parties. On a national level as well, the investigation and prosecution of the core international crimes is of vital importance to victims and to ease the burden on the court. Joint initiatives such as the 2023 Ljubljana The Hague Convention on Mutual Legal Assistance and Extradition are key examples of what we can do and achieve if we work together. We urge states parties to consider ratifying the convention as well. I thank you.
Je vous remercie.
Thank you very much. And I just wanted to point out that on our list I have 3 further delegations, UK, Palestine, and DRC. We are going to have no choice but to close the speakers list after those 3. Now I'd like to hand over to the United Kingdom, who requested the floor.
Thank you, Ambassador Alabrun, for giving me the floor. On behalf of the United Kingdom, I would firstly like to thank the co-facilitators, Ambassador Alabrun of France and Ambassador Bafé of Senegal, for their dedicated work on this important topic this year. Without international cooperation, this court could not function.
Without cooperation between states parties and the court, impunity is left unchallenged. This is in no state party's interest. As we said in our national statement, the relationship between the court and states parties is symbiotic, and this is nowhere more relevant than in cooperation. If we expect the court to deliver for us, then we must deliver for the court. The Non-Cooperation Toolkit provides a valuable resource to help states parties, domestic authorities establish clear systems to monitor and ensure best practice in cooperating with the court. Last year, the court suffered a devastating cyber attack and was subject to threats and intimidation against its staff. This year, those same threats continue. Security is paramount to the effective functioning of this court, and the UK calls upon states parties to support where they can. The UK recently made a donation to the Registry's Special Fund for Security and continues to be supportive of the court in budget discussions to get what it needs to ensure effective reinforcement against future attacks. As reflected in the court's concept note from May 2024, the Agreement on Privileges and Immunities of the Court forms an important layer of protection for its officials in these volatile times, including when they leave office. We call on states parties to give full effect to this agreement and urge those states parties that have not yet ratified the agreement to consider doing so. I thank you.
Je vous remercie.
Thank you very much. Now I should like to hand over to the State of Palestine. Representative, you have the floor.
Thank you, Ambassador, for giving me the floor. The State of Palestine welcomes the report on cooperation with the court and thanks the facilitators for their work and dedication. We recall the obligations of states parties to cooperate with the court and operate in all circumstances in good faith, consistent with the object and the purpose of the court. While the court is being threatened and debilitating sanctions that will affect the functioning of the court and kill the promise of the Rome Statute, we are also faced with the actions and statements by few states parties openly opposing and challenging the jurisdiction of the court and protecting war criminals. Remarks by Hungary inviting Israeli criminals or sending letters of support, or by Argentina ignoring the arrest warrants and sending solidarity to Israeli war criminals, or those releasing contradictory statements depending on the religion or origin of the victims, are part and parcel of the existential threat facing the court and undermine its effectiveness and efficacy. Cooperation includes respect for the court, assist the investigations, and implement and enforce court orders, including for arrest and surrender of suspects. Cooperation includes protecting and upholding the integrity of the ICC and all of its organs from political attacks or undue influence by states and organizations. Cooperation is ensuring justice and accountability for all victims of international crimes. Cooperation is ensuring that there are no double standards, that no one is above the law, and the law applies equally to everyone. The Rome Statute creates a binding legal obligation for states parties to uphold its tenets in both domestic and international contexts, ensuring the objectives of the statute are fully achieved. The State of Palestine will continue to cooperate with the court and will use all legal, diplomatic, and political means to ensure that states parties cooperate with the court in the situation in the State of Palestine. Thank you.
Thank you. And I give the floor to the representative of the Democratic Republic of Congo. Thank you very much, Ambassador, for giving me the floor. The Democratic Republic of Congo is very happy with this debate and to encourage the work that is being carried out with regards to co-facilitation that you're carrying out with Senegal. We would like to recall the great importance that there is to be accorded to cooperation. It is true that the court only lives through these pillars of cooperation and complementarity. Cooperation is necessary. How can we imagine a court which reaches objectives for which these states are deployed in Rome, employed themselves in Rome, if the states don't execute arrest warrants? For protection of witnesses in states, the DRC is completely committed in this fight against impunity by facilitating the greatest possible cooperation, and we invite the partner countries the state parties to do so as well. Cooperation seems to be a fundamental pillar. How can the court function? It doesn't have a police force in states. It does not have structures, administrative structures to do this. The states have to give it the necessary means. And this is why we consider in the DRC that cooperation is essential, absolutely essential. And we will continue to offer all means available to make it possible for the court to fulfill its mandate by way of example beyond what the fact that Congo DRC signed the Rome Statute. It has also negotiated the agreements, and the delegate members was the negotiator for the DRC, and we are committed greatly to this cooperation, not only for crimes under the Rome Statute, but for other crimes as well, international crimes. When it comes to criminals and suspects, the DRC will never accept that a request that comes from the court is not met with. Thank you. Thank you very much. As such, we have heard the different delegations of states parties who were on the list, and I now give the floor to civil society organizations. The representative of the Ukrainian Legal Advisory Group, you have the floor.
Excellencies, I'm honored to deliver this statement on behalf of the Coalition for the International Criminal Court. The court's ability to fulfill its critical mandate depends on the multifaceted cooperation by its states parties. This is particularly true when it comes to the execution of arrest warrants, which affect the access to justice before the ICC of victims like the ones my organization, Ukrainian Legal Advisory Group, represents. Public arrest warrants remain outstanding against 30 individuals, including 2 sitting heads of state, with others issued under seal. The Rome Statute and the court's jurisprudence are clear. States parties have a legal obligation to arrest and surrender individuals wanted by the ICC, and head of state's immunity is not opposable in proceedings before the court, regardless of the nationality of the individuals. Public statements from states parties casting doubt on this in relation to certain arrest warrants are not only in contrast with the Rome Statute and the court's jurisprudence, but they threaten the equal execution of the court's global mandate, victims' equal access to justice, and the fundamental principle that no one is above the law. All states parties should instead clearly and publicly commit to abide by their legal obligations to execute ICC arrest warrants, regardless of whom they target. This would send a strong message to those individuals who see themselves as untouchable, and to victims across the court's docket that their right to justice and affirming their trust in the rule of law matters more than political calculations. States parties should also be prepared to respond strongly to instances of non-cooperation. Failure to do so severely affects cooperation with the court, particularly on arrests. Finally, civil society organizations, particularly those representing victims, are concerned by continued meetings between senior state party and UN officials and Russian President Putin, an ICC fugitive on the territories of non-state parties. The Assembly's resolution on cooperation urges states parties to avoid non-essential contacts.
Thank you very much, and I would ask you to conclude, because you've exhausted your speaking time. Thank you. Thank you very much. I would really like to thank all the delegations who have spoken on cooperation, and they have shown that cooperation through their great discipline with their speaking time. And as such, we have finished the first segment. I would once again like to thank you for your very rich interventions. Thank you to the panelists, the high-level panelists, for their presentations. And I would now like to invite the speakers from the second panel to join us on the podium. how to support the efforts of the ICC in order to chase the people subject to an arrest warrant. On the first point, where it concerns the ratification of APIC in order to protect the court, I would like to stress that in reality there are many different ways of protecting the court, and the interventions of our experts will explain exactly how. Without further ado, I would therefore like to give the floor over to Madame Antonia Pereira de Sousa, Chef de Cabinet of the Registrar. Thank you very much, Madam Ambassador. Thank you, Mr. Ambassador, and to you as co-facilitators on cooperation for this opportunity to address the Assembly on this essential issue of APIC and the protection of the court. As the annual resolution on cooperation states, it's a priority for the states parties who haven't yet done so to ratify APIC and to incorporate it into the privileges and immunities in their national legislation. And today, only half of the states parties have done so. This is of mutual interest for states and also for the court, as the court has also recalled in its annual report on cooperation. And I would briefly explain to you the two main reasons why this appears to us to be fundamental. Firstly, where it concerns the operations of the court on privileges and immunities, and thereafter where it concerns protection of staff of the court. With regards to privileges and immunities, with regards to operations, the state parties under Article 48 of the Rome Statute have to respect the privileges and immunities of the court, and this is necessary in order to accomplish its mission. And paragraph 2 and 4 of the article privileges and immunities are for specific categories of court functionaries as well. And depending on the general nature of Article 48 gives rise to different interpretation, and this is the reason why that we encourage the states to adopt, by way of complement, APIC. In the implementation of our mandate, we can be confronted with different challenges if this question of the interpretation of the application of the legal dispositions are not present, for example, when there is travel to states which are not APIC parties, and the registry has developed a practice of sending a note verbal which is based on Article 48 of the Rome Statute in order to give privileges and immunities applying to the travel. And that's not just the existing legal protections of APIC, but as you will have heard, this does create legal, financial consequences which are additional, and it can also complicate the preparatory work. And when it comes to the implementation of the work of the registry, this is a problem which also comes up when it concerns the mandate of the registry and for defence teams in the implementation of their mandate when they undertake missions of investigations. And in this context, APIC appears to us to be an essential instrument to increase the clarity and legal security, specifying the privileges and immunities of the court. And also adhering to APIC and by ratifying this, states can ensure coherent privileges and immunities on their territory. Now, the second part concerns the protection of ICC staff, as we have stressed in our conceptual note, which was shared by the court at the request of the states parties within the framework of facilitation on cooperation. The ICC and the judges and the prosecutor and the deputy prosecutor and the registrar, when they exercise their functions within the framework of the activities of the court, they have a large scope of privileges and immunities, which are those which are for chefs de mission. And when these privileges and immunities are accorded to these elected functionaries, then they cannot be subject to any type of arrest or detention, and the states take all measures which are appropriate to prevent any harm to their person or restriction of their freedom or attack on their dignity. Now, the other members of staff, with regards to them in the CART, the council, the people who assist others, they also have privileges and immunities which they benefit from. So it's clear for us that the Rome Statute, APIC, and the Headquarters Agreement are a solid and coherent basis which establish that the states parties and those they have the obligation to fully protect the officials of the ICC against any coercive or restrictive measures of any type whatsoever, such as measures aiming to prevent the independent exercise of their functions and duties or taking reprisals for any acts taken by way of reprisal. Please could you conclude? I shall conclude by recording that within this context, we have called in this conceptual note for the Assembly of State Parties to adopt an action plan which is concrete with the work that's been carried out in the context of the recommendation 69 of the report of the Independent Expert Review, and the conceptual note which I've also shared with you makes it possible to identify a clear route to ensure this protection of court officials. Thank you. Thank you, Madam de Souza, for this very rich presentation. Without further ado, and on this, talking about how APIC can protect the court, I would like to give the floor now to Mr. Wunderberg. I hope that I've pronounced the name correctly.
Merci bien.
Thank you very much.
The Kingdom of the Netherlands would like to underline the importance of supporting the court. The last few years, the ICC has faced unprecedented threats. We recall the cyber attacks against the court, which had far-reaching consequences for the court itself, as well as its elected officials, staff, and witnesses. Furthermore, we have seen that arrest warrants are issued against elected officials and are now confronted with the possibility of sanctions which could threaten the court's very existence. It is the responsibility of each state party to the Rome Statute to ensure that the court and its organs are able to carry out their mandate independently and unimpededly, without threats, without intimidation. It's a responsibility that we should not underestimate, as the court is crucial in the global fight against impunity of the gravest international crimes. By ratifying the Rome Statute, we as states parties have committed ourselves to assisting and supporting the court in fulfilling its important mandate. As the host state of the court, the Kingdom of the Netherlands has experience in taking measures that can be taken to protect it, including the protection of premises, its officials and witnesses. Based on our responsibilities and legal obligations as set out in the Headquarters Agreement and the Agreement on Privileges and Immunities, APIC, we assist the court in order for it to operate safely and independently. We underline, however, that especially when it comes to threats that are not exclusively limited to the territory of the Netherlands, it is important that each state party assist the court in tackling these issues. The general responsibility to assist the court based on the Rome Statute, but also on the obligations based on the APIC, provide a legal basis for every state party to take measures in its national capacity to assist the court. We can think of examples such as the protection of elected officials who receive threats, cybersecurity measures, or efforts with the aim to mitigate the effect of possible sanctions. We would like in particular to address these possible sanctions that could be imposed on the ICC and its staff, as they may have serious consequences for the court. To name a few: suspension of services from affiliated banks. This would mean that the majority of transactions could be declined, meaning that salaries, loans or contributions from states parties can no longer be paid or received. Insurance companies that may no longer want to cooperate with the ICC. Hindering staff members in their ability to travel. Hampered maintenance of its software, which could also mean that the ICC is unable to properly protect itself against future potential cyber hacks, and consequently, confidential information that has been shared by the court by states may become public. Undermining and termination of investigations in all regions of the world, focusing inter alia but not exclusively on situations such as Ukraine, Darfur or Venezuela. Arrest warrants may be revoked, detainees may be released. Closure of ICC's field offices, including in Ukraine, at a time when Ukraine is on the verge of becoming its 125th state parties to the Rome Statute. Or hampered witness protection. Moreover, we should all bear in mind that grave harm to the interest of the many victims that may occur as a result of these possible sanctions. It is our shared responsibility to support the court and to cooperate to mitigate risk of these possible sanctions so that the court can continue to carry out its work and fulfill its mandate. Thus, for the sake of the court and for the international legal order, we have to cooperate and act in accordance with our legal obligations and responsibilities. And therefore, we also underline the importance of becoming a party to the APIC. Merci beaucoup.
Merci beaucoup à vous.
Thank you very much. So, without further ado, I will give the floor to Virginie Amadou, the Director of the Coalition for the ICC. You have the floor, Madam.
Madame l'ambassadrice, merci beaucoup.
Madam Ambassador, thank you very much for giving me the floor.
Gentlemen, dear colleagues, civil society organizations and human rights defenders are on the front lines of efforts to ensure justice for victims of serious international crimes. A critical part of that work has always been to insist on state cooperation with the court and to defend the court and Rome Statute system from efforts to undermine them, often at great personal risk. The Coalition for the ICC is highly concerned by the series of unprecedented threats aimed at preventing justice before the ICC. These include calls for sanctions against the court by elected officials in Israel and the United States of America, Russian arrest warrants against the ICC prosecutors and judges, the surveillance and intimidation of ICC elected officials, human rights defenders, as well as cyber attacks. States parties have come together in the past to defend the court against interference and obstruction, and will need to do so again now. As a coalition of hundreds of NGOs around the world, we urge states parties and all relevant actors to ensure that the court can continue its work and that victims can still find hope somewhere when there is nowhere else to turn. Important steps have already been taken. The coalition welcomes the strong state party support so far, including the statement issued by 94 states parties in June, declaring unwavering support for the ICC as an independent and impartial judicial institution, and reiterating the commitment to uphold and defend the principles and values enshrined in the Rome Statute, and to preserve its integrity from any political interference and pressure. The Assembly Presidency has been vocal in condemning attacks on the court and its officials aimed at undermining the ICC's mandate, making use of the Assembly's strategy adopted last year to respond to threats and attacks against the court, its officials, and those cooperating with it. We welcome the expressions of support and concern expressed in many statements to the general debate and this plenary session, and the language of this year's upcoming omnibus resolution explicitly mentioning sanctions. Going forward, further action is needed, particularly to address potential US sanctions that could have a wide effect on the ability of the court to do its job, and also create serious risk for all of those supporting the court, including states parties and civil society. For these reasons, we offer the following recommendations. First, words continue to matter. We urge you to keep up a strong public case for the centrality of the ICC to a global rules order, to international peace and security, and to the rights of victims to see justice in all situations where the court acts, and to make that case directly to the US government and Congress. Second, how you deal with your own obligations matter with regard to defending the court against the sanctions. As my colleague Arya mentioned in his statement, there can be no hesitation, no selective justice, no room for ambiguity as to your obligations under the Rome Statute. The support and defense of the institutions need to be clear and unconditional. Your cooperation will only need to increase in the face of the threats. Third, states parties and regional institutions should advance towards the adoption or implementation of national and regional blocking statutes, such as the European Union Blocking Statute. Even if their impact is limited, this type of legislation remains a critical tool right now, and perhaps the only available ones. Blocking statutes and similar instruments can provide the court and its partners essential protection and sends a powerful message that the states parties will not tolerate efforts to undermine the court. Fourth, states parties should also look at other concrete measures they can take and share that knowledge within the Assembly and with the court. We also call on states parties to anticipate any coercive measures by engaging with your domestic or regional service providers to ensure that they will continue working with the court. Fifth, states parties that have yet to do so should indeed immediately ratify the court's APIC, As it was noted earlier, to date, only 79 states out of the soon-to-be 125 have ratified the APIC. In the past 5 years, only 2 states have ratified the APIC, Mongolia and San Marino. Universal ratification and implementation of the APIC remains key. Finally, we are also concerned about the impact of these sanctions on those cooperating with the court. We know too well that sanctions with the court create apprehension and uncertainty for NGOs, consultants, and lawyers working with the ICC. These new sanctions will inevitably have an impact on victims, legal representatives, and civil society. Yet the commitment and resilience of civil society and human rights defenders for justice and victims of atrocity is as high as ever. Many human rights defenders themselves and their families in ICC country situations face pressure, intimidation, even criminalization in efforts to silence them and stop their work on behalf of victims. And in turn, this undermines the ICC's implementation of its mandate. We ask states parties to implement measures to protect and defend those cooperating with the court against attacks.
Please, could you conclude? Thank you.
Taken by states parties will have an impact. Time is of the essence. It is important for you, states parties, to show you're willing to act. We're willing to engage with you. Thank you so much.
Merci beaucoup.
Thank you very much. I would like to thank the different speakers on this subject relating to the court security and APIC, and the ratification by states can only increase the independence and effectiveness of the court as an universal court. Without further ado, we shall go into our second point, which is how to use ICC's tools to facilitate cooperation between states parties and the court. And in this regard, I would like to give the floor over to Madame Verna Adkins, legal advisor at the Permanent Representation of Finland to the United Nations, and one of the 5 focal points for cooperation. Madame Verna, you have the floor.
Thank you, Madam Co-Facilitator. Excellencies, ladies and gentlemen. I'm honored to participate in this panel as a representative of the at-country focal points on non-cooperation, Mexico, Poland, Sierra Leone, Vanuatu, and Finland. The group of focal points was established to assist the Assembly President in the exercise of the President's good offices with a view to promoting full cooperation with the Court. The states parties have entrusted the ICC with the enormous task of investigating and prosecuting the serious and complex crimes under the Court's jurisdiction. However, the Court can only go so far without the support of states parties. Enforcement of arrest warrants issued by the Court is a fundamental obligation of states parties. The Rome Statute and the jurisprudence of the Court are clear on this. My role today is to outline the tools available for the Assembly and the states parties to prevent and address non-cooperation. There are 2 tracks, formal and informal, under which the Assembly can address non-cooperation. These are outlined in the Assembly's procedures relating to non-cooperation. First, the formal procedure for the Assembly to address instances of non-cooperation is only triggered by a legal finding of non-cooperation and a decision by the Court to refer the matter to the Assembly. There is a variety of measures available under the formal procedure, including the convening of an emergency bureau meeting, open letters from the Assembly President to the state party in question, invitation for the requested state to attend a meeting of the Bureau to discuss the implications of the Court's decision, the convening of a public meeting with the requested state, noting the Court's decision in the omnibus resolution, a Bureau report on action taken and recommendations, and discussion in plenary session. The Bureau could also appoint a facilitator to consult on a draft resolution containing concrete recommendations on the matter. In some cases, the good offices of the Assembly President can continue to take place in parallel. Second, the Assembly has at its disposal the informal dimension of the procedures relating to non-cooperation. The informal response procedure and the toolkit for its implementation provide guidance on the use of the good offices of the President and the focal points to respond to an impeding or ongoing situation of non-cooperation. including in respect of a request for arrest and surrender, in which urgent action may help bring about cooperation in that specific case. The matter should be raised informally and directly with officials from the requested state and other relevant stakeholders with a view to promoting full cooperation. The focal points assist the President in the exercise of the President's good offices. Where appropriate, states parties should be encouraged to engage in the outreach. The toolkit for the implementation of the informal dimension of the Assembly procedures contains guidance for states parties and relevant actors on implementing non-cooperation procedures, notably on the monitoring of the travel of persons subject to arrest warrants, on preventing instances of non-cooperation, on sensitizing interlocutors on non-cooperation issues and aspects related to cooperation vis-à-vis Security Council referrals. The toolkit provides an indication of concrete measures that can be taken by the Assembly President, the focal points, and states parties. These include pre-agreed templates and formulations for draft statements, note verbals, speaking points, media releases, and tweets in different scenarios. Civil society can play an important role in assisting states parties in the implementation of certain measures. Lastly, the focal points on non-cooperation emphasize that the Assembly's work to prevent and address non-cooperation is in the interest of all states parties and our shared responsibility in support of the Court and for the success of the Rome Statute system. Thank you for your attention.
Merci beaucoup, Madame Vernin.
Thank you very much, Madam. And now I'll hand on Anne-Aure Bautran, Acting Chief of the Judicial Cooperation Support Section. Over to you. Thank you, Excellencies, dear colleagues, and dear Galax. It's an honor to address you today for this most important subject. What I wanted to do was share a few insights with you as to how we can, in the registry, foster cooperation with states and stakeholders. Cooperation, as we've heard, is a cornerstone for ensuring fair and effective judicial proceedings. So the mandate of JCSS is to support judicial proceedings by adopting a coordinated and strategic approach to judicial cooperation. This responsibility is carried out through our Judicial Cooperation Unit, which handles a broad range of cooperation requests, and our Suspects at Large Unit, which is the primary point of contact between chambers and states for executing arrest warrants. When an order is issued by chambers, our section is responsible for drafting and transmitting requests for cooperation and engaging with states so that they can be implemented. And these requests aim to get cooperation on various issues such as tracing and freezing assets, interim and final release of suspects, and arrest and surrender. Should states and parties block or delay or fail to respond to these requests for cooperation, we report to the chambers and seek their extra guidance. And in most cases, we work with states to discuss their challenges related to implementing such requests. Now, I should like to talk about the consultations about Article 97 of the Rome Statute. The Court knows about the challenges that some states face when requested by the Court to cooperate, particularly as concerned an arrest and surrender request for suspects at large. If there are such challenges when states parties have to strike a balance between their legal obligations under the Rome Statute on the one hand and geopolitical obligations of a political nature on the other. And as the registrar noted, it's important for states parties to adopt a consistent, harmonious approach that upholds the rule of law. To support states, the Court strongly encourages states parties to initiate Article 97 consultations where should they identify any problems that could impede or prevent them from executing any request. And this mechanism aims to facilitate dialogue and problem solving between the court and states parties so as to ensure cooperation while all the while addressing any legal or practical challenges. These have been used successfully in the past, particularly when it comes to arrest and surrender requests. And so we do think that it's useful for the court and for states parties if it's used with timeliness and good faith. Article 97 consultations is supposed to ensure that there is notification of any difficulties, and in this way guarantee that any requests by the court are actually able to be implemented in a timely way. And at the same time, chambers can ask states parties to submit their observations, and the section is there to ensure that they can do this.
And surrender, I'll just switch to English. I would like to highlight that in line with the described range of cooperation request, the registry and my section in particular, we're always available for state parties to respond to questions and clarify concerns about the request for cooperation we transmit. Particularly on requests for cooperation relating to suspect at large, the registry is also counting on proactive action from state parties. In this regard, I'd like to once again draw your attention to the toolkit on cooperation that was just discussed, which, for example, for the monitoring of suspects, forces that the states should proactively inform the court of travels of fugitives using their diplomatic networks and other means, such as information from civil society or intelligence agencies. This is very useful for the court.
Madame Bertrand, vous voudrez bien conclure?
Could I ask you to conclude, please?
The court, as it takes significant resource on our side to monitor the travel of more than 30 suspects. And the address that is mentioned in our brochure is still available. So I will just conclude to indicate that your cooperation is crucial and that my team and the registry is available to assist in any difficulties you can meet. Thank you.
Merci beaucoup, Madame.
Thank you very much. Now, I'm actually going to come back with you because when you took the floor, you actually brought us to the end of that second segment. But now it's time to get to the third and final segment, which is how to support ICC's efforts to track persons under arrest warrants. And again, I'm going to give the floor to you, the acting chief, and also to Tom Lynch, who is special advisor to the prosecutor, to clarify on this issue. Remember that both of your sections work hand in hand so as to ensure that the court's efforts in this regard go smoothly. Thank you. Over to you.
C'est un honneur de m'adresser à vous aujourd'hui dans le cadre du segment.
So, yes, it's an honor to address you on this technical segment as well on cooperation. Among the various different forms of state cooperation, none is more fundamental to our mission than that of arrest and surrender of suspects at large, because there can be no justice without the presence of those who have to stand and face it. I'd like to start by just reaffirming that this is a primary responsibility for states parties. It's a core obligation under the Rome Statute, unequivocally enshrined in Part 9 of the Rome Statute. And arrests of ICC's suspects at large are not political decisions. They're binding imperatives under international law. To fulfill this obligation, states parties need to ensure that their national legal frameworks are in place to ensure that they have a domestic ICC arrest warrant provisions in the law and be ready to address specific cases, efficiently closing any legal or procedural gaps that could hinder cooperation. In September of this year, the court adopted the recommendations for increased engagement with states parties on the implementation of outstanding ICC arrest warrants. suggesting how states parties can provide operational, financial, and political support. To give you an example, political support could take the form of providing diplomatic support, for example, in favor of the registry's request for arrest and surrender. Operational support, on the other hand, could be things such as issuing rewards for information leading to the capture of suspects at large. And the court, for its part, recognizes its responsibility to facilitate and enable arrests. The registry and OTP adopted a more standardized approach on tracking any suspects at large, because they realized that states parties did need assistance before initiating arrest operations. And this assistance sometimes is detailed information about the suspects' or whereabouts or activities or anything that could lead to the location of the suspect. And so they have separate but interconnected mandates, the registry and the OTP, when it comes to tracking suspects. And the OTP's strengths lie in accessing information on the location of suspects in the investigation phase, whereas the registry, as the neutral organ of the court, is conducting tracking activities in isolation of other prosecutorial activities, solely focusing on collecting information related to the execution of warrants of arrest and adhering to any decisions issued by chambers. And the strengths of both organs are bundled into the Interinstitutional Suspects at Large Working Group, or the SALWEG, where the registry and the OTP coordinate activities related to tracking. Now, remember that you've got different kinds of functions, capacities, and strengths of both organs that can be mobilized for fugitive tracking. And it's by sharing intelligence and closely coordinating with state parties that the court hopes to maximize its chances of arrest operations. Now, to better illustrate this, I just wanted, along with Tom Lynch, just to give you a fictional case, but it's inspired by real-life operations conducted with states parties this year. And this example that we're going to share with you undisguises the meticulous but often unseen work undertaken by the court and its partners. While the arrests themselves are highly visible milestones, they are the culmination of tireless granular efforts behind the scenes. So here we have this fictional case is Mr. Müller. He's a Minister of Defense in a given state. And in 2019, there was an arrest warrant, and he was accused of crimes against humanity. And here we had basically 4 different categories of arrest warrant at our disposal, either public, confidential, under seal, or secret. Under seal and secret means that the substance of the arrest warrant can't be discussed with our partners, and in this particular case, what we chose was under seal. Now, what's important for us here is to see what was the political context if we were going to get this arrest strategy implemented. You have to understand that he was in the fictitious Republic of Brasana, and this republic, first of all, we had to decide, was it a signatory or not to the Rome Statute? And so, as you can guess, we've got more chance if it's a state party. And then we needed to look at all of the surrounding political context to see whether it was going to be possible, whether it was going to be easy or not for us to get our hands on Mr. Müller. And then we had to identify strategic partners so that we could work out whether they would be able to give us a diplomatic operational assistance. And then we would come up with strategic recommendations based on the information of that. And in parallel, obviously, we also develop the profile of Mr. Müller. We use 3 different kinds of tracking information sources, either information based on human intelligence sources. And what we use there also we also use media, because lots of our suspects are actually present on social media accounts. And then we also use intelligence provided by states parties. For example, do we have satellite images that, provided by the state party? For example, this year in our operations, the registry was able to use these kinds of sources, geolocation of some suspects at large, and they were able to work with staff from the OTP who were able to provide the satellite images, and therefore were able to confirm the information that we'd had according to our sources. So this is a good example of how the two organs can work together and come to a successful outcome. And also, as we work together, and we work on these three different kinds of sources. And we maintain contact with all the intermediaries who could potentially provide us with information. Then we analyze the information that we've had, and this means that we can anticipate any upcoming travel, for example. We want to understand how frequently the person travels, where they tend to travel. And we can also see if we've got any additional incentives that we could build on, because this might be a really good way of identifying sources who could give us further data. That way, we could say it might actually be worth, even here in the ASP, discussing whether it would be worth having an incentive program. So once we've identified which state party we're going to work with and when, that's a good start.
Okay, thank you, Anne. And in the spirit of cooperation between OTP and registry, I'll finish up this presentation of this scenario and then just give a few words about specifically the work that the OTP is doing on tracking and arrest. So to follow on what Anne was describing, in this specific scenario where we know where a suspect is but cannot arrest due to the fact that the host country is either not obligated to or not willing to, we do monitor the travel of all of our suspects. In this fictitious case, monitoring the travel of Mr. Mull, who then travels to an ICC state party in which we begin an arrest opportunity. There are other scenarios where an arrest opportunity may arise due to the tracking efforts of the court. For instance, where a suspect is not traveling, but we need to locate where he is, and we engage with intermediaries and using some of the other advanced techniques that Anne mentioned to determine the exact location and possible moves of the suspect into a state where we might be able to pursue an arrest opportunity. The first, when engaging with a state who will be or may be conducting an arrest operation, the first thing that we would do, mostly a registry task, would be either to retransmit the request for arrest and surrender to that state, or if it has not yet been transmitted, to transmit for the first time. Then there would be there was a joint high-level mission to the state that might be conducting the operation. And that would be both a registry OTP mission. Sometimes would require several follow-on missions, as was the case. And then we would begin to operationalize the recommendations that have been referred to earlier by engaging with other states who may be able to assist either neighboring or regional states or other states that have an interest in an arrest opportunity. And then we ended up with the requested state successfully conducting an arrest operation thanks to this approach and to the intelligence provided by the registry and the OTP. To summarize some of the key challenges related to suspects at large, the first, well, not really in any particular order, but first is operational challenges. This usually arrest operations require significant logistical and security, detailed logistical and security operations. It also requires political support, judicial cooperation, legal support, for instance, when there are gaps in the domestic law of a particular country. And of course, all this must be done in a confidential manner to avoid risks of leaks that could undermine the operations. So Again, in this scenario that Anne has put forward and I've complimented on, I think it demonstrates the kind of a real-life scenario of how we would go about conducting an arrest, a tracking, arrest, and surrender operation. Now, I will just conclude by talking a little bit about the developments or changes within the Office of the Prosecutor over the past year or so with respect to our tracking and arrest efforts. First has been a shift in mindset. Tracking and then hopefully, arrest and surrenders have been even further prioritized. As has been mentioned earlier, there has been an increasing number of warrants, yet a decrease in the number of trials, and we need to dedicate further efforts to increasing the number of trials. What does prioritization mean within the Office of the Prosecutor? First, it's more dedicated resources of staff dedicated just to working on tracking and arrest. And second, and probably most importantly, it's to integrate tracking into the investigations of the OTP from the outset. Too often, tracking is seen as an add-on or supplementary function, that not only marginalizes tracking efforts, but misses key investigative and analytical steps that need to be taken. Also using advanced tools, the Office of the Prosecutor has spent the last several years leveraging technology to increase our investigative and analytical tools, and this has led to concrete results. And then, as Anne referenced earlier, greater synergies between the Office of the Prosecutor and the Registry. We have separate but certainly interconnected mandates, but ultimately this comes down to cooperation. And while we do hope that states will cooperate, we also acknowledge that we as the court need to do more on our side, and we look forward to engaging in a more robust manner moving forward. Thank you.
Merci beaucoup.
Thank you very much, both to Madame Bertrand and to Mr. Lynch, for this most relevant presentation on exactly how the organs of the court can work together to ensure successful arrest operations. Now, I'd like to hand over to the Minister of Uganda to tell us about their experience in this area. Thank you very much.
Thank you, Moderator. Heads of delegations and representatives of state parties, officers of the International Criminal Court, distinguished ladies and gentlemen. First, let me thank the ambassadors of France and Senegal, who are the facilitators for the working group on cooperation, and their delegations for giving us the opportunity to share reflections on Uganda's experience on cooperation. Judge Antonio Kasese, the first president of the International Criminal Tribunal for the former Yugoslavia, once described that tribunal as existing very much like a giant without arms and legs. It needs artificial limbs to walk and work. Let us take a moment and try and visualize an encounter with such a giant, no limbs. It would be a giant that is not really a force to reckon with. It would not be intimidating, challenging, or anything. Judge Kasese went on to say, if the cooperation of states is not forthcoming, the International Criminal Tribunal for Yugoslavia cannot fulfill its functions. It has no means at its disposal to force states to cooperate with it. This is what the court is like without cooperation. It's huge in name, intimidating, frightening for perpetrators of international crimes under its jurisdiction, but without the assistance of artificial limbs, it cannot function. We believe that the first step to making cooperation meaningful is to establish a framework. Uganda was among the first countries to enter into a cooperation agreement with the court. Cooperation agreements should address all aspects of the court's activities under the Rome Statute, including but not limited to protection of victims and witnesses, enforcement of sentences, and interim release and release of persons. I'd like to reflect on two aspects of cooperation. The first one is behind-the-scenes operations. We have made covert, indeed secret arrangements to facilitate the travel of key witnesses in many situations before the International Criminal Court. The nature of most cooperation takes the form of confidential negotiations. This includes cooperation in regard to conducting of secret investigations, confidential witness support and protection, relocation of witnesses, provision of safe houses, provision of detention facilities, and the protection of critical evidence, to mention but a few. All this Uganda has done. As you know, Uganda is hosting the highest number of refugees in Africa and is the third highest refugee hosting country in the world. Therefore, Uganda, on account of that fact, is home to many persons of interest in several situations before the International Criminal Court. We therefore pride ourselves in being one of the court's most cooperating state parties. Our cooperation goes beyond our obligations. We are also cooperating with the Trust Fund for Victims. They are right now carrying out outreach programs in northern Uganda. This enables the implementation of the Trust Fund's secondary mandate. We are also cooperating with the civil society. We give them a conducive environment to ensure that they work unhindered. We believe that the civil society plays an important role in the work of the court. When the civil society organizations seek to engage on our territory, they should do it in an ordinary manner. We call upon the civil society to see the government as their friend, not their enemy. A lot of your work will be made easier if you work with the governments, since we are your partners in defeating impunity. The final aspect of our cooperation is the public forms. This takes the form of court orders. The main one is really arrest warrants. Since there are live matters before the court, I will not talk much about this aspect. But let me suggest that beyond the established mechanisms in place to address non-cooperation for the failure to effect arrest warrants, there is really need for dialogue. Let us examine the circumstances and context of each situation when it arises. Finally, no form of cooperation is too small. None is more important than the other. We don't wait until we have more than enough to do something. As far as Uganda is concerned, when duty calls, we will be there and on time. I thank you for listening.
Thank you, Mr. Minister, for sharing this Uganda's experience. À ce stade des travaux, je
It's now time for me to open the floor for any delegations to take the floor if they've registered and would like to share their experiences or their expectations concerning support for the court by using the existing tools. I just want to remind everyone that there is a 2-minute speaking time limit. Now, I should like, first of all, to ask the Republic of Korea and their representative to take the floor.
Thank you, Madam Chair, for giving me the floor. As everyone here emphasized today, the court cannot work alone. All state parties must cooperate closely with the court and take action against serious crime. Since becoming a member on February 23, Korea has actively supported the ICC work in various ways. For instance, in November 2023, the Ministry of Justice co-hosted the ICC's Asia-Pacific High-Level Regional Seminar in Seoul. The event was attended by more than 100 invitees, including then ICC President Piotr Hofmanski, former ASP President Sylvia Fernandez, ICC Deputy Prosecutor Najat Khan, and delegation from over 10 Asian countries. In addition, the Republic of Korea plans to sign the agreement on the enforcement of sentence with the ICC, becoming the first Asia-Pacific country to do so. By signing the agreement, Korea hopes to contribute to the enforcement sentence under the Roman state and promote universality in the Asia-Pacific region. The Korean Ministry of Justice and the prosecution are also making significant effort to closely support the Office of the Prosecutor of ICC in each investigation. Especially in the MRI cases, we are taking every effort to execute the request of OTP. In addition, the Ministry is considering sending experts, including prosecutors and investigators, to support ICC investigations. As a state party to Roman State, I assure you that the Republic of Korea remains fully committed to cooperate with the ICC. Thank you so much.
Merci beaucoup.
Thank you very much. Now, would the representative of Japan kindly take the floor?
Voilà. Vous avez la parole.
You have the floor.
Co-facilitator. Let me begin by expressing my gratitude on behalf of the government of Japan to co-facilitators, Ambassador Alabuhun and Ambassador Bafaye, for your initiative and facilitation through the Hague Working Group on the topic of cooperation. In terms of ways to strengthen on support to the court, Japan, I'd like to, I wish to introduce its effort for the provision of capacity building opportunity and the promotion of dialogue with stakeholders in the field of international law. In view of the increasing number of situations and cases handled by the ICC, it's important to strengthen the capacity of state parties, especially developing countries, in the field of criminal justice as a crucial element of cooperation under the Rome Statute. In October 2022, the United Nations Asia and Far East Institute for the Prevention of Crime and the Treatment of Offenders, UNAFEI, which is based in Japan and operated by its Ministry of Justice, concluded a memorandum of understanding with ICC for the capacity building activities. Since then, UNAFEI has been providing support for capacity building in the field of criminal justices, by deepening the relationship with ICC through inviting ICC judges as a lecturer for UNAFEI. From September to October this year, UNAFEI held a seminar on witness protection in collaboration with Victim Witness Section, VWS, on the registry. Prosecutors and officials of witness protection agencies from various countries, including non-state parties, gathered together to share and learn knowledge about the best practice on witness protection in each country and witness protection measures implemented by...
Je vous invite à conclure.
I would invite you to conclude.
So finally, Japan reiterated its commitment to support ICC by providing such capacity building endeavors. Thank you very much.
Merci beaucoup. Maintenant, j'invite le...
I would now invite the representative of Belgium to speak.
C'est Belize.
Is it Belize?
Belgique?
Madame et Monsieur les co-facilitateurs.
So, thank you, co-facilitator. Thank you. It is indeed Belgium. Thank you for giving me the floor. Sorry, that was a technical issue. It is indeed Belgium. So, as other people have said, so cooperation with the International Criminal Court is vital to make it possible to exercise its functions, and this is what the states parties wanted it to do when it ratified the Rome Statute. This gives us the opportunity to look at the different means available to us to transform our commitments into actions. Firstly, it was highlighted that the Accord on Privileges and Immunities ratified by the states parties is a key tool to make it possible for the court to deal with possible threats against it, giving it protection which is indispensable while giving it full independence and security. Secondly, it's up to the states parties to give it the adequate means in order to meet in a quick and efficient way the cooperation request of the court. Furthermore, there's an appropriate legal framework which can be made by designating a focal point for cooperation, but also by concluding cooperation agreements with the different organs of the court. In this regard, we very much welcome the states parties who recently concluded new cooperation agreements with the court, in particular on the occasion of the plenary session of this Tuesday, 3rd December 2024. Thirdly, the execution of arrest warrants constitutes one of the most important obligations of states parties. Indeed, the efficiency of the work of the court depends ultimately on the capacity of states to bring before them the people who are being prosecuted. So it's fundamental for states parties to give themselves the necessary means to reflect their observations, to cooperate and to arrest suspects in accordance with the Rome Statute and the jurisprudence of the court, including by providing with all assistance required with a view to locating persons at large. And if you would allow me, I would just miss my duty if I didn't also mentioned the Netherlands by inviting the states parties to ratify the agreement, which can be considered a natural extension of the states parties to make it possible to implement the complementarity regime. Thank you so much. Thank you. I will now like to invite our last speaker on the Bolivia. Thank you very much, President. I'm going to speak in my capacity as a representative of Bolivia, and I would like to point out that cooperation is essential to meet the mandate of the ICC and in order to achieve international criminal justice and to make it a reality. So Bolivia signed the Rome Statute, and we see the need to keep making progress in effective cooperation at judicial level with complementarity, and it's a key element of the Rome Statute system. Furthermore, we recognise very much the work done by the co-facilitators from France and Senegal in the actions which they have carried out for cooperation. What I want to do at the same time is point out different elements, highlighting that, furthermore, my country has signed the agreement on privileges and immunities of the International Criminal Court, and furthermore, it is important when it comes to cooperation for have states parties able to ratify this instrument to cooperate, which is only 50 countries have done so. Now, the second element that I wanted to point out with regards to cooperation is what also the delegate from the Ministry of Uganda pointed out on the need to make progress on these cooperation agreements between the court and the states. I think also, as a third element, that it's also important to note that cooperation which comes under the Ljubljana Convention on International Cooperation and from the judging of international crimes. This is an instrument which is multifunctional and very useful for these challenges which the court has. And I think that it would be important as well to make this instrument universally applied. Furthermore, the work of the prosecutor is fundamental when it comes to the other organs as well. And I think that all these arrest warrants as well, which are issued by the court, need cooperation in order to be executed. And what is unacceptable is when they are not. And that's the last point that I want to make, but I see that the time is being pointed out. But it's not acceptable if states parties do not implement the arrest warrants and do not comply with their duties. This is a challenge that we have for cooperation. And I will conclude by saying the importance that there is. Your time's up. It's essential that we guarantee international justice by complying with our duties. Thank you very much, Ambassador. We have closed the list of states parties. Now, with regards to the part of civil society, I'm going to invite Darfur Women's Action Group to take the floor.
Good afternoon. Thank you for the opportunity. As I speak to you today, serious international crimes has been and continue to be committed in Sudan today. As we all may recall, that 20 years ago, the world has been shocked by the first genocide in the 21st century, a type of crimes that this court is set to address and prevent. And because of this reason that the case of Darfur was referred to the International Criminal Court. Unfortunately and sadly today, the scope and the magnitude of victimization of the very victims who have been attacked 20 years ago has been allowed to go far for too long. And it's impossible to be described in words. And this is due to the lack of cooperation in the case of Darfur, because some states have failed to cooperate in enforcing the arrest warrant issued by the ICC for those who are wanted to face and supposed to face trial. It is very unfortunate because by doing so, it sends a signal to the perpetrators that they can go away with immunity, but also shows survivors and victims that they don't matter. And by doing so, perpetrators have been emboldened in Sudan and continue to commit crime, including today, something that needs to be stopped. I know you all agree that you want this court to succeed, and the court's success lies in its ability to pursue perpetrators and to deliver justice to the deserving victims. And we have seen the failure to cooperate firsthand in the case of Darfur. And we are always eager to see progress made by the court, particularly in the recent cases that more.
Merci, Madame. Je vous invite.
Thank you, Madam. I would invite you to conclude.
Been identified very high-profile suspect or criminals. But what I would like to note is that make no mistake, if the court is unable to bring Bashir, it will send a signal that it is less likely to bring these new powerful leaders that are recently indicted.
Thank you, Madam. Thank you very much.
And I will be very brief.
Thank you.
Merci beaucoup, Madame.
Thank you, Madam.
This court succeeds and also protect the victims so that perpetrators will not kill the victims before they can see justice delivered. Thank you.
Merci beaucoup.
Thank you very much. I would like very warmly to thank all our speakers. We are now at the end of the second session of our plenary. I would like to give the floor back to my dear colleague, Francois, for the closing remarks. Thank you very much. I would also like to thank all the speakers, the panelists, the representatives of states parties, representatives of civil society. We have listened with great attention and great interest to the interventions which have made it possible for us to better understand these subjects which we work on in the framework of facilitation, and in particular on the tools that already exist within the court. And it is important that we are able to use them as best as possible. Of course, I take into account that through the diversity of the different interventions that have been made, I think that we must work together. The court, states parties, non-state parties, international actors, civil societies, everyone must be involved in dialogue between different actors, in particular to enable the tools to work which we've spoken about. And among the actors, I would like to stress the particular importance that there is of the focal points where it comes to cooperation. This is essential for the court, and I would like to pay tribute to them. This plenary session is closing, and it has been co-facilitated by us. I would like just to say how much I have enjoyed working with my friend Ramatoulaye, and I would also like to thank the Secretariat of the Assembly of States Parties for the work which has been carried out over the years. Thank you to the interpreters, thank you to all our teams and to everybody who works within the framework of this facilitation. I wish you all an excellent follow-up of this 23rd Assembly of States Parties. Thank you.